And hello, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, I hope you enjoyed this legal education content, and today is the day I earn that subscription. For today's story, we are doing a couple things. First of all, we are testing out a brand new web camera. So we're going to try that and see how that goes. So I decided to try to get this brand new web camera. This is not sponsored, by the way. The Insta 360 link. It's a 4K AI webcam, and it can do fun AI things. For example, if I move, it will move with me. Ooh! I see. I can lean back in my chair. It'll zoom in automatically. Lean back, zoom back. Kind of cool, right? And it can also do other things. And also, what's nice about it is it also will flip on its side so that you can do vertical videos, which makes shooting shorts a lot easier in the future. So, if this works out, what we will expect to see going forward, what we'll expect to see going forward is the normal videos that appear on my normal channel will still be shot with my normal camera. So my normal camera is a Sony Alpha 5100. It's 24 megapixel ASPC sensor, right, with a really nice lens on it, the Sigma 30 millimeter, and it's a really good quality camera, right? So all the web camera in the world can't quite do all that. So the normal videos you see on my channel will continue to be done that way. But what I'm intending to do going forward is producing a whole bunch of shorts, and that requires doing vertical video. So rather than rotating my main camera, right, this web camera can flip on its side. So I will film the videos doing that, right, and I'll put them on my shorts channel, and hopefully that will be good. We'll see. And that is part of the plan. Also, by the way, it can do other fancy things, right? It has gesture control. So for example, it will follow me, but I can tell it to stop doing that, right? I can do this, and then it won't do it anymore. See? But if I do this, now it'll follow me again, right? And wait, I don't feel like I'm zoomed in enough. I don't feel like you're getting enough of the Kurt experience. No problem. Yeah. So you got gesture control, right? All kinds of fun stuff. So we will shoot vertical video using this probably in the future is probably what that will go. Plus, of course, if I'm on the road, it is something that will be a much better quality webcam. It also is nice because it's got a 1/2-inch sensor in there, and so it lets in a lot more light. So even if I'm streaming in 1080 like I am now, I am streaming in 1080, right? Let me double, I actually didn't double check my settings. Even if I'm streaming in 1080, yes, even if I'm streaming in 1080, this camera is capable of 4K. But even if I'm streaming in 1080, right, it gives you a lot better control. Okay, and the webcam again, in case you want to get it yourself, this is brand new, just came out on the market. It's Insta360 Link, the AI powered webcam. It also has fast autofocus. So yeah, it can do some really fancy stuff. So we'll see how all that works. But that is you should join other people's cameras with the new camera out. Tell them about all the gimmicks. I definitely will not be telling other people about the gimmicks, but you'll know the secrets. Okay, anyways, that's a little bit too much inside baseball, but now you know what we're trying to do. So this is the new mobile setup, right? We've got the camera, we've got the lavalier mic, and so we can do pretty good stuff on the road. So this is our intention, or at least we're playing with it on the road. All right, so that is business item number one. Item number two is well wishes to our chief moderator, Stephanie. Stephanie, as many of you know, has been sick for a long time. She has talked about it on her own channel to some degree. She's been in the hospital very recently and having been recently released, she's back in the hospital again. And we are just wishing her well, and hopefully we'll hear more from her soon. So just my best wishes to Stephanie, and hope that this will be a speedy recovery for you. We're all pulling for you. and you're one of the strongest people that I know. So if anyone can do it, I know you can. We believe in you, Stephanie, and we're wishing you the very, very best. All right. So with all that being said, let's go ahead and get started with our main story, which is the Marilyn Manson thing. So last time we covered part 1. We covered the complaint. And it made very, very specific allegations. Marilyn Manson has alleged that his former girlfriend, Rachel Wood, along with her girlfriend, whose name is Gore, conspired together to defame him and inflict emotional distress. Manson's claim is that Wood and Gore conspired together to make a lot of very salacious claims regarding his behavior, including sexual assault, and not only that, conspired with other people, so they were the principal conspirators, but then got other people to come into the conspiracy to make further allegations against him. They got other women to make charges against him. And Manson is the one suing. He's the one on the offensive. So he's saying that all this is not true. I never assaulted any of these women. These women. These are all false claims. They're all false. And Gore, principally, is the one behind it. Gore is a drifter who has conned everyone into all this, and that is what's going on. So that's Manson's claim, basically, long and short. Right? Now, we're going to, and of course, on top of that as well, they did a whole bunch of other things, including, for example, faking a letter from the FBI, which they sent off to people in an attempt to gain credibility, including, I think, at least in one case, filing false documents with courts. So he's alleging basically fraud before the court. He's alleging fraud. He's alleging conspiracy. He's alleging that there's been basically a conspiracy against him, and that he's never assaulted any of these women, and it's not true. So that is what we covered in part 1. So now we're going to cover part 2, which is Wood's reply. So Wood has filed a motion to strike under an anti-slapp. She says the lawsuit is based off of her protected First Amendment speech, namely the First Amendment speech being that he, is a serial abuser, and she is bringing attention to that. So she is claiming that this is all just false. And so we're going to try to look at that and see what's going on. So let's go ahead and get started with this. So we'll skip the introductions, skip the table of contents, and we'll go into the body of the memorandum. For years, plaintiff Brian Warner had sexually assaulted and physically abused Rachal Wood and threatened retaliation if she told anyone about it. So Rachal Wood is saying, no, this is all things that happened to me. He did the horrendous things. He's saying it's lies. I'm saying it's true. Warner has now made good on these threats by filing the previous lawsuit. In it, he seeks to hold Wood liable for defamation and intentional infliction of emotional distress. Yeah, I mean, if it's false, yeah. Based on Wood's decision to publicly name Warner as an abuser and to talk to Warner's other victims, who may or may not exist. Manson says they don't exist. Wood says they do exist. Many of Warner's claims arise from protected activity, and all are meritless. They should therefore be stricken as a violation of the strategic lawsuit against public participation. Okay. Warner asserts an IIID claim based on declaration filed in a parentage action between Wood and his ex, James Bell. And her ex, I apologize, James Bell. Warner alleges that Wood's declaration attached a purportedly fabricated letter from the FBI, which states that Wood is a key witness in a criminal investigation of a well-known public figure and safety is of utmost concern. But court filings are quintessential examples of protected activity. I mean, to some degree, yes, but you're committing fraud upon the court, so there's that. And Warner's IIED claim is barred by both the litigation privilege and the First Amendment. I mean, okay. It is also meritless, as Wood did not fabricate the FBI letter. Warner is the subject of an FBI investigation. That doesn't mean the letter is authentic. And Warner cannot demonstrate any of the elements required to prevail on a claim of intentional infliction of emotional distress. I'm not sure if that's true. I mean, a lot goes to whether you believe him or not in terms of this. But if, and of course, on a pleading, right, we normally assume that the pleading is true for the purposes of a motion to dismiss, right? So we normally would assume that everything Warner's saying is true for that limited purpose. So he says it's false. If he says it's false and a lot of other people say it's true, then maybe it's just an issue of credibility, right? If one person says this didn't happen and 10 other people say it happens, well, then it's just how the jury assesses it, right? And the jury probably will believe the 10, but there's no guarantee. I mean, maybe they think all 10 people are liars, right? You never know with juries for sure. And it's up to the jury to weigh things. So if the claim is, look, I say it's true and Gore says it's true and a whole bunch of other women say it's true, but Manson says it's false, well, it could just be a straight credibility fight. And if it's a straight credibility fight, it's a question for the jury. So I'm not sure that's true, but okay. Second, Warner IIAD's claim is based on Wood's communication with other victims arising from protected activity and should be stricken. I mean, it depends whether it's true or not, right? If it's true, then it's protected. If it's not, it's not. Wood's communication remained in connection with legislative reforms. That doesn't mean you can lie. Criminal investigations also doesn't mean you can lie. And civil litigation further doesn't mean you can lie. And they concern domestic abuse by a public figure, clearly a matter of public concern. Yes, but you would know whether or not it's true or not because you were there. So we can meet actual malice, right? Because if he says it's not true and you say it's true, then it's up to the jury who do they believe. And if they believe it's not true, then you would know an actual malice is proven. It's kind of the same thing with Amber Heard, for that matter. Third, Warner asserts IID and defamation per se, based on statements purportedly made by another defendant that the actress in Warner's groupie video was underage when the sexual and violent film was made and is now dead. Courts have consistently found statements about child abuse are protected activity. Yeah, but not if you know they're false. That's the whole problem. And this is particularly true given Warner's celebrity. Again, if you know they're false, then you have a problem. Like the protection to report things doesn't really go to whether if you know for a fact they're wrong. If you're confused, mistaken, a lot of things, it can protect you. But if you're just making it up, and that's Warner's claim. Courts have consistently found statement okay. Because Warner cannot demonstrate that Wood made any false statements, he might be able to. I mean, he can just say they're false. Like, because I didn't do that to you. And you say you did. Then it becomes a credibility fight. Or that she acted with actual malice. He can demonstrate that. You would know. His claims must be stricken. I don't think so. All right, so here's a statement of relevant facts. Now, again, in a motion to dismiss, and unless California is special in some way when it comes to an anti-slapp, right? In a motion to dismiss, and an anti-slapp is just a special motion to dismiss. We gave it a special name and everything, but it's just a special motion to dismiss. That's what an anti-slapp is. It has special rules. It has special procedures, remember? A slap, by the way, in case I missed it, is a strategic lawsuit against public participation. So the idea is I'm suing not because you really did something wrong. I'm suing to shut you up. That's a slap. A strategic lawsuit against public participation. You have First Amendment rights. I'm suing you not because of actual complaints I have, but merely to get you to shut up, right? And so we invented a special motion to dismiss called an anti-slapp to deal with this. And it has special rules. One of the things that it gets you is attorney's fees. And it also allows you to act faster than a motion to dismiss would otherwise act. So it's a motion to dismiss. It has special rules, but it's a motion to dismiss. So the standard rule should still apply. We assume everything Warner says is true. So like what you say is true shouldn't really affect that unless California has special rules. Maybe you'll get into the law, but I would assume that your counterfacts are not relevant to the motion to dismiss. But we'll find out. Here's what you say is true, at least. Wood met Warner in 2006 when she was just 18 years old. Legal. Warner sought out Wood at a party and told her he was a big fan of her work in 13, a teen drama where Wood plays a 7th grader, dabbling in drugs, sex, and crime. Warner said he wanted to talk to Wood about a project he was working on. By this time, Warner was already a music icon, having taken the Marilyn Manson persona in 1989. Okay. Although the relationship began as a friendship and professional collaboration, one day Warner kissed Wood. So like so many relationships, began in the workplace and then went further. Okay. Warner was still 18. Warner was 37. Well, you're both legal adults, so do you. Warner and Wood then began a romantic relationship that continued on and off until 2010. Because Warner and Wood are both celebrities, their relationship gained a great deal of public attention. Okie doke, that's fine. What seemed as a seemingly loving relationship became increasingly abusive over time. During the course of this relationship, Warner abused Wood by, among other things, forcing prurient activities on her, physically mistreating her, electroshocking her, threatening her, blackmailing her, hacking into her accounts, and isolation from friends and family. Finally, in 2010, Wood found the courage to leave Warner for good. Well, Wood is definitely telling a very vastly different story than Warner, but that's a disputed fact, right? He says none of this happened. She says it happened. She has other people that says it happened. Sounds like an issue for a jury, right? If we're going to start assessing who's telling the truth, that's what juries are for. Although she escaped from the relationship with Warner in 2010, coming to terms with the profound effect of years of abuse and feeling safe enough to talk about it, despite threats of retaliation, took much longer. Wood did not speak out about the abuse until 2016, and she was not publicly ready to name Warner as her abuse until years later. That's fine. I mean, that's understandable. Once Wood began speaking out the abuse, she connected with other activists. In February 2018, Wood testified before U.S. Congress to promote implementation of 2016 Bill of Rights across the country. Wood testified to some of the horrific details of abuse she suffered, but still did not name Warner as an abuser. Nevertheless, after testifying before Congress, Wood was contacted by other women who claimed to have experienced abuse by Warner. After learning she was not Warner's only victim, Wood approached a prominent attorney with evidence of Warner's abuse, but she learned the statute of limitations for Wood's claims against Warner had already expired. Yeah, I mean, that sounds right. Shocked that there was no longer a remedy for the horrendous crimes committed against her, Wood began advocating to extend the statute of limitations. In April 2019, Wood testified again, this time before the California Senate in support of the Phoenix Act, a bill that passed an extended statute of limitations for charges of domestic violence. Okay. Once again, Wood testified the type of abuse she discovered, but declined to name Warner. All right. On February the 1st of 2021, Wood identified Warner as her abuser in an Instagram post saying the following. The name of my abuser is Brian Warner, also known to the world as Marilyn Manson. He started grooming me when I was a teenager and horrifically abused me for years. I was brainwashed and manipulated in submission. I was done living in fear of retaliation, slander, or blackmail. I am here to expose this dangerous man and call out the many industries that have enabled him before he ruins any more lives. I stand with victims who will no longer be silent. Many other women have also accused Warner of abuse. Both the LA Sheriff's Department and FBI have launched investigations of Warner, and Wood has provided evidence in connection. At least 4 women have also filed civil suits against Warner based on abuse. Okay. On March the 2nd of 2022, Warner retaliated by filing the present lawsuit against Wood and another woman who worked on the Phoenix Act, Ilma Gore, who is Wood's girlfriend. Warner then filed a lawsuit less than 2 weeks before the premiere of Phoenix Rising, which chronicles Wood's experience as a domestic violence survivor. In the complaint, Warner asserts a whole bunch of things, which we've discussed before. Okay. Warner alleges that Wood and Gore impersonated a federal agent by creating and distributing a fictitious letter. The FBI letter said, "Please be advised that Miss Evan Rachel Wood is a key witness in connection to a criminal investigation in Los Angeles, involving international and well-known public figure. The safety of Miss Wood, her family, other victims, and friends are the utmost concern." Warner is not specifically named. Well, we know that doesn't necessarily matter. The complaint alleges that Wood submitted the FBI letter in a California custody proceeding, using it as supposed evidence for why she should be able to move her son to Tennessee. The complaint also quotes from Wood's confidential declaration in the parentage action, alleging the following statements from Wood were untrue: that she was advised by criminal investigators that me and my family's safety was at risk, and to punctuate the seriousness of the situation, was provided from correspondence from a representative of the Federal Violent Crimes Department of the FBI, which doesn't exist. The complaint does not specifically allege Wood distributed the letter other than in custody proceedings. So you only committed fraud before the court. Okay. Warner's IIAD cause of action includes a claim based on Wood and Gore purportedly falsifying correspondence from a fictitious federal agent claiming there was concern for the safety of Wood. The complaint also alleges a separate IIAD claim on Wood and Gore purportedly recruiting, coordinating, and pressuring multiple women to make false accusations against Warner and to be part of the film project. Specifically, Warner alleges that Wood and Gore used their work advocating for the Phoenix Act and in connection with the Phoenix Rising documentary, and to recruit, coordinate, and pressure women who have been linked to Warner to make false accusations. According to the complaint, Wood and Gore coordinated allegations and devised the specific buzzwords, phrases, and talking points that prospective accusers would use when they gave interviews. That is what he said. And he provided a checklist that apparently had been prepared by them to give them, and also a script that apparently had been written, or at least remnants of notes relating to a script. The complaint further alleges that Gore and Wood status as famous actresses and the criminal investigation of Warner to get potential accusers to meet and coordinate allegations which were filmed in Phoenix Rising. Warner alleges that purported false statements made to prospective accusers have been repeated in civil lawsuits made against them. Yes. So there's a lot of stuff happening. I mean, some of this stuff is happening in court lawsuits, but to the extent that they are talking outside the court process and trying to recruit people and getting them to submit false documents to courts, like, there's a lot of conspiracy there. I mean, there's a lot of speech that's going on that's outside of court documents. So I don't think that the court document thing is necessarily dispositive. Come on. I'm still learning the ropes of the thing. But anyways, yeah, I think there's a lot of stuff that's still out of protection there. Let's read on. The complaint alleges IIAD claim and a cause of action for defamation per se, based on purported statements about the movie. Specifically, Warner alleges that Gore told unnamed third parties during the filming of Groupie the actress in the video was a minor and the actress was dead. Yes, that's apparently what's going on. Warner contends that Gore understood the statements to mean Warner's role in the making of Groupie as CP was criminal, adding that Gore stated that Groupie was evidence of felony and that Warner would be indicted. But Warner does not attribute any statements about Groupie to Wood, but alleges that they condoned and encouraged them. Yeah, that would be the nature of them being in the conspiracy with each other. So yeah, she didn't necessarily make the statements, but they were in agreement, conspiracy, which, if true, would make her responsible for all the things. Now, let's see if I can get this camera. What part of this is as a camera beta test. So is the camera still following me? Okay, the camera's still following me, so it's still doing that. Now if I do this and I zoom in, come on. Come on, come on. There we go. A little more zoomed out. I'm still working on it, getting used to it. So yeah, we'll make do. But anyways, this is the nature of the conspiracy, right? If you're in a conspiracy with someone, you basically absorb everything your co-conspirator is doing. That's part of the nature of conspiracies, and why it's a bad idea to join conspiracies. Like, oh, I didn't do it, my co-conspirator did. Yeah, that's not really going to work as a defense. So yes, you didn't yourself say it, but Gore did, and his allegation is you're in a conspiracy, and he has some evidence that supports that proposition. And so maybe it's just an issue of fact between you. Yeah, the magic show. Yes, I know the magic show. It's we get the magic camera that follows me around the room. Oh, yeah, the magic camera that does all the things now. So yes, we are testing equipment to see if we like it. It's an expensive webcam. So it will do what I need it to do, and if it does what I need it to do in terms of doing vertical videos, it might be very good indeed. And for the road, it's really nice. Between that and the lav mic, we can actually get something done. Now, if I could only figure out how to make it work with StreamYard, that would be great. Because this was originally set up in StreamYard, and I couldn't get it working in StreamYard. But I could get it working in OBS. So I hijacked my own stream from StreamYard, and then just opened it in OBS, because I couldn't quite make it work. Maybe another time. We'll figure it out together. L for loser? Cute. All right, let's read some more. What is the relevant legal standard? Under the anti-slapp statute, it will also do, by the way, it'll also do really cool stuff. Like it'll do a top-down view, so it, like take pictures of the desktop. It'll flip down with a gesture, and you can also do a gesture where it will zoom in on a whiteboard. So in the future, maybe I'll have a whiteboard, and then I'll make the gesture and I'll zoom into the whiteboard, and it'll be all super fancy and stuff. I don't know. We'll see. Anyways, under the anti-slapp statute, any cause of action against a person arising from any act that person in furtherance of that person's right of freedom of speech in connection with public issues shall be subject to a special motion to strike, which is just a motion to dismiss, which California calls a demurrer, because, we have to have different names for the same thing, but whatever. Unless the court determines the plaintiff has established, there's a probability the plaintiff will prevail. So you have to determine there's a probability of prevailing, apparently in California. The legislature has mandated the statute shall be construed broadly. Okay, fine. An anti-slapp motion need not attack an entire pleaded cause of action. Mixed causes of action, those that include both claims based on protected activity and claims based on unprotected activity, are analyzed as follows. Because she apparently hasn't moved to dismiss the whole thing. She's only moved to dismiss part of it, for whatever reason. Perhaps only part because only part relates to her. But yeah, so she's not moving to dismiss the whole thing. So how's California treat with that? At the first step, the moving defendant bears the burden of identifying all allegations of protected activity and the claims for relief supported by them. When relief is sought based on allegations of both protected and unprotected activity, the unprotected activity is disregarded. If the court determines the relief is sought based on allegations arising from activity protected by a statute, the second step is reached. There, the burden shifts to the plaintiff to demonstrate that each challenge claim based on protected activity is legally sufficient. So unprotected activity can move forward, but any protected activity cannot, if ultimately proven, which makes sense. In other words, courts should analyze each claim for relief, each act or set of acts, supplying a basis for relief, of which there may be several in a singly pleaded case of action, determine whether the acts are protected, and if so, whether the claims they give rise to has the requisite degree of merit to survive the motion. If they cannot demonstrate the claim for relief based on protected activity has merit, those particular allegations will be stricken, which makes sense, right? If you're only moving to strike some of them, then you strike some of them. If something is still there, then it's still there. Okay, applying these steps leads only to one conclusion. The allegations and claims for release based on the FBI letter, Wood's communication with other victims, and the alleged defamation must be stricken. She might be technically right on the FBI letter, but her communication with other victims, no. Like, it's only protected if it's true. If it's not, it's false, which is the whole nature of it, right? Yeah, it's like, even if those other victims are really victims, she's not. She can't spread defamation. Like, it wouldn't make sense. I mean, to some degree, right? It's like, if you're in a group and 4 people are saying things and be like, yeah, but me too, but you're not true, you're spreading lies. And you're bolstering a claim that shouldn't be bolstered. So, that kind of makes sense. How's everyone doing, by the way? Has the chat completely stopped and died? There we go. There's some more chat. I was worried there for a second. Okay. There was no chat. I was concerned. I hope all y'all are having a great day. Under the first step, Wood need only show that Warner's claims arise, at least in part, from Wood's act in furtherance of right of petition or freedom of speech. Wood meets this burden based on demonstrating the act underlying their claim fits one of the categories spelled out in the law. All right, filing the FBI letter in the parentage action is protected activity. Let's give that a try and see whether or not that's true. Here, Warner's IIID claim is based on a purportedly. When do I go home? I don't know. You think I should ever go home? I don't know. Maybe I'll never go home. Maybe it'll just be me here forever, talking to you against a beige wall. Maybe I'll never go home. Maybe this is my home now. I'm talking to you from a box somewhere. Let's see, where was I? Did I glitch into the back rooms? Something like that. Something like that, yeah. Let's see. Court's filings are a textbook example of protected activity. The subsection defines a act in furtherance of a person's right to include both any written or oral statement made before a legislative, executive, or judicial proceeding, or any other official proceeding authorized by law, and any written or oral statement or writing made in connection with an issue under consideration or review by a legislative, executive, or judicial body. It's hard to believe that extends to like completely forged letters, but I mean that is the way the law is written. So maybe California's just dumb, which is not unheard of. All petition-related acts performed by parties or their attorneys are per se protected. By protecting all petition conduct, the legislature created a reasonable, bright-line test applicable to a large class of potential section motions. Okay. Moreover, courts have consistently held that filings in family law proceedings are protected. So your fraud before the court is protected by the legislature, at least as it relates to a third party. Like the court might have an issue with you, and the legislature might have an issue with you, but as it relates to a third party, it's protected. You might be right. That's dumb, but California can be dumb. The FBI letter and any alleged communication between Moore and Warner victims about the FBI or its content also constitute protected activity. I'm not sure about that. Statements in connection with official proceedings. I don't think it goes that far. To the extent you filed it in court, maybe. To the extent it exists outside of court, I don't think you can get to it about statements in connection with. I don't think that's what that had in mind. Home is where my hat is. That is a fair point, Emily. That is a fair point. The hat is lonely. That is a fair point. Warner's IIID claim based on the FBI letter arises from Wood's petitioning activity. Indeed, the complaint specifically references the submission of the FBI letter in a California custody proceeding. Warner may argue his IIID claim does not arise from Wood's filing of the letter, but rather from the alleged fabrication of the letter. Any such argument would fail. First, whether or not Warner's allegation about the fabrication is true, and they're not. Okay. The act of forging a letter cannot cause distress to someone unaware of its existence. I mean, that's true, I suppose. Is the FBI's letter publication through the court filing not its creation that would create any distress? Moreover, the act of preparing documents to file in court, even if prejudicial or forged, qualifies as privileged petitioning activity. Okay. If you say so, under the relevant California law, I'll take your word for it. It wouldn't surprise me that California's that dumb, but okay. So your filing this forged letter is protected activity in California. Okie doke. All right. Otherwise, every defamation claim based on alleged false statement and declaration fall outside the anti-slapp. That's not quite true. That's hyperbolic conclusion, but whatever. Because Wood has demonstrated that the IID claim based on the FBI letter arises from protected activity, it shows to Warren to establish by clear, competent, admissible evidence a probability of prevailing. All right, let's see. Warner cannot establish a probability of prevailing on his IIAD claim based on the FBI letter because it's barred by litigation privilege. Okay, the privilege applies to any communication made in a judicial or quasi-judicial proceeding by litigants or other participants authorized by law to achieve the object of the litigation, and that it has some connection or logical relation to the action. Okay, I mean, all right. Communications with some relation to judicial proceedings are absolutely immune by litigation. To effect this purpose, the litigation privilege is absolute and applies regardless of malice and has a broad application, so it doesn't matter how much we lied. Put another way, application of the privilege does not depend on the publisher's motives, morals, ethics, or intent. All right, if you say so. Here, Wood's declaration attacking the FBI letter was filed in a parentage action. The declaration and its exhibits are clearly communicated with some relation to judicial proceedings. Thus, they're absolutely immune from tort liability by litigation privilege. This is true regardless of whether Wood forged the letter. She did not. Or knowingly made false statements in her declaration. Again, she did not. Tilly T gives 10 gifted memberships. Well, at least your gifted memberships show up in OBS's chat. They don't show up in StreamYards, but they do show up in OBS. So I will say thank you, Tilly T. Thank you very much for your nice contributions to the channel. It is appreciated. I appreciate you helping out the channel to support some gift memberships. And, everyone should thank Tilly T who got a gift membership. Everyone is awesome. What I really need is the StreamYard thing to pop up on the screen. I'll have to add that for later. I didn't think to do that for today, but later. You want to know if Wood's dog stepped on a bee? I'll let you know if it comes up. The privilege has been applied specifically in the context of claims alleging the following of false or perjurious testimony or declarations. Okay. According to apparently a California appellate court, IIAD claim based on filing false police reports and prosecuting civil harassment petition was barred by litigation privilege. So you might be right under California specific law as it relates to your court filings because California is dumb. California is allowed to be dumb, though, as we all have determined for sure. So, yeah. All right. Even if litigation privilege did not apply, Warner could not meet the burden of demonstrating a probability of prevailing. The elements are outrageous conduct, intended to cause or reckless disregard of the probability of causing emotional distress, severe emotional suffering, and actual or proximate cause. Warner cannot meet this burden with respect to any element. First, Wood's conduct was now outrageous. Well, contrary to the allegations of the complaint, Wood did not impersonate the FBI. That's a factual claim, though. So you can't win on that. Right? You can't really win on that. You can win on the litigation privilege, if that's true. But you can't win on a dispute of facts. Not in a motion to dismiss, which, again, an anti-slapp is just a fancy motion to dismiss. When Wood received the copy of the FBI letter and when she filed with the court, Wood believed it to be authentic. Really? Wood had every reason to believe the FBI letter's authenticity because Wood had been providing evidence to the FBI and the LA County Sheriff's Office in connection with investigations of Warner and fear for her safety based on Warner's threats and past conduct. You believed it? It wasn't on FBI letterhead or... Okay. All right. Likewise, Wood did not knowingly make any false statements in her declaration. In short, there was no impersonation, no forgery, and no perjury. Wood's actual conduct explained to the court why she fears living close to the man who had assaulted her was in no way outrageous. It is Warner who acted outrageously. Well, but those are a lot of factual allegations. Again, maybe that's true, maybe it's not. But you can't win on a dispute of facts at this stage. That's for someone else to resolve. Second, Warner cannot meet the burden to prove Wood filed the FBI letter with intent to cause distress to Warner. Wood did not file the letter to cause Warner distress, but rather explained to the court why living close to Warner was distressing. Indeed, because the letter was submitted in connection with a parentage action to which Warner is not a party, Wood did not know that Warner would ever receive a copy of the letter. Documents and records filed in parentage actions are not publicly available, and only subject to inspection in exceptional cases. Warner apparently became aware of the FBI letter because it was leaked to the press. Leaked by whom? Is a good question. Who had a copy of it? But Wood did not distribute the FBI letter outside of the custody dispute. Who else had it then? Gore? Did not provide to Warner and did not leak it to the press. Thus, Warner cannot prove an intent to cause distress. That might be true, but if Gore did it as part of the conspiracy, you'd still be on the hook anyway. Like, all that could still be true. That all could be true. If Gore forged a letter as part of the conspiracy, even if you don't know about it, you're on the hook. Once again, the nature of conspiracies. Don't do conspiracies. Third, Warner cannot meet the burden to demonstrate severe emotional distress. Indeed, apart from conclusory allegations that Warner suffered distress, the complaint does not give any specific allegations. There may not be enough specific detail to survive an IIED. Maybe we need more. That's fair. That's a fair point. Warner cannot meet the burden to prove that any distress claims to have been suffered were caused by the FBI letter. If Warner has suffered distress, it's not because of a perfunctory letter. It would be if the letter was circulated to others. The letter itself might not be, even filed in court might not be, but if the letter was circulated to others as part of your conspiracy, that would be causing distress because it creates accusations against him, bolsters accusations against him. So I don't think that quite holds, but all right. Finally, a public figure like Warner may not recover for the tort of intentional infliction of emotional distress based on publication of a statement about him without showing the publication contains a false statement of fact. The entire letter is a false statement of fact, though. The fact that it's signed by the FBI is a false statement of fact. The FBI letter states that Wood is a key witness in connection to a criminal investigation involving an international well-known public figure. The safety of Wood and victims is the utmost concern. See, that's a false statement of fact. It's not of the utmost concern. Not to the FBI, and not to the Violent Crimes Division, which doesn't exist. So, that doesn't quite work. She might be right on the law as it relates to it being filed in court. She might be right on that. So, to the extent that there's a fair point. Like, Warner would never know about it and stuff like that. But to the extent it exists outside of court, to the extent that it was shared with others as part of the conspiracy, even if Wood herself never shared it with anyone, like if Gore did, then and they did it as part of the conspiracy, then you're on the hook for that. The left hand doesn't have to know what the right hand is doing in a conspiracy. This is the nature of conspiracies. Don't do the conspiracies. So I'm not quite sure it quite holds. But there's some interesting ideas there as it relates to the court-specific activities. But I think Warner's claim goes beyond that. The IID claim based on Wood's communication with other victims should be stricken. In addition to speech and petitioning activities with legislative, executive, and judicial proceedings, protected activity includes any written or oral statement or writing made in a place open to the public or a public forum in connection with an issue of public interest, but you made statements beyond that. You made statements in private, apparently. And any other conduct in furtherance of the exercise of the right. Yeah, but you didn't just make speeches in public places. The conspiracy is alleging that you made statements outside of like formal hearings. You made them in like, as part of a conspiracy in private. So that wouldn't extend. The accusations Warner references are statements made by Wood and many other victims accusing Warner of domestic violence. These statements were made on social media, in press interviews, and survivors' meetings. Those are not. I don't think that qualifies as what they're talking about in the statute. Courts have consistently held that communications regarding this are matters of public interest. Yeah, the public interest, I'll give you that that's a public or a place open to public or a public forum. The press interviews, I don't think it's a public forum within that meaning. Survivors meeting, that's not a public forum. It might have become open to the public. That's not quite what that is. Public interest in allegations of assault and domestic violence have only increased since Me Too. So survivors of abuse must be able to speak with other survivors of abuse without being sued. Not if they're lies. That's the problem. Warner alleges that War and Gore enticed potential accusers to alleged abuse by suggesting they're already amassing evidence for a claimed ongoing investigation. Warner is the subject of criminal investigations by the FBI and LA Sheriff's Department. You would have no way of knowing if that's true. They might have told you that's true. They might have been lying to you, but you don't know that. Statements in anticipation of or connection with a criminal investigation are protected. To some degree, that's true, but I think you're overstretching here. Legislation also alleges that Wood and Gore used the Phoenix Act and the work as an activist to recruit and attract potential accusers. Okay. The fact that Wood and other victims are accusing a world-famous celebrity of domestic violence heightens the public interest in the accusations. Oh, I'm interested. Can I do what I want to do with... No, I probably can't. I was going to see if I could change resolutions on the fly. No, I can't probably do that in OBS. Just to see if I could. I wonder what happens if I do this anyway. This will be interesting. Let's see what happens. This is all part of camera test time. All right, let's see if I change from 1920 to 1080. Can I change the resolution? No, apparently I can't. Not while I'm streaming. Damn it. I was looking forward to screwing with the video. Oh well. This is how we learn things. My trying. Anyways, let's go back to the story. Story and camera test. I kind of like the fade in, fade out. On my, I haven't set it to 0 like I have on my home computer. Because normally when I switch, it just does it instantly. I think maybe the fade in, fade out is actually kind of good. Maybe I'll keep that. Maybe I'll go back to having a fade in, fade out. Oh, there's other kinds of transitions. Ooh, what else can we do? There's a cut. I don't know what cut is. Let's find out. Oh, that's just no time. Swipe. What does this happen? Ooh. That's fancy. What is this? That's very similar. Keep the fade. What else we got? Fade to color? I don't know what that means at all. Let's try this. What happens if I do this one? Luma wipe. What is a Luma wipe? Linear horizontal. What does this do? That's kind of cool. Tilly T gives 10 pounds. Kurt, is this a Fed case meaning it won't be televised? No, it's California state. So I don't know what their filming policies are there. It's not federal though. It's in the state courts of California. So we may get this filmed and shown on the TV someday. So yeah. Star wipe? I don't think I have a star wipe feature. That's disappointing, I know, for everybody. But I don't think I have a star wipe. I guess they thought that we were not cool enough for a star wipe in this. There's one that adjusts the sizes. That would be great. We'll look into it. At least 4 other women filed lawsuits. In the complaint, Warner alleges some of those statements made to prospective accusers have since been repeated by those in court filings. Yeah, but they were made outside of court filings too. They can't establish a probability of prevailing. Yeah, I don't think that's true. Cannot identify any false statements made by Wood to any of the other victims, and therefore Warner's IID claim is barred by First Amendment. Cannot meet the burden to prove severe emotional distress. That part might be true. Common law privileges. Warner's claims arise from protected activities. Like Wood's other communications, Gore statements concerning a matter of public interest are protected activity because they're made in connection with legislative reform, criminal investigations, civil litigation. Not connection enough. And because they concern abuse by a public figure, I don't think so. Warner cannot sue Wood for defamation based on statements Wood did not make. You can as part of a conspiracy, which is exactly what's being alleged. Warner cannot demonstrate that Wood acted with actual malice when Gore allegedly made the false statements. Again, if it's part of a conspiracy, that's the nature of conspiracy. You don't have to know any of it's happening. You don't have to know any of it's happening. You don't have to participate in any of it. If it's part of your agreement and they're doing things behind your back, you don't have to know about it. And you're still guilty. That's what conspiracies do, man. So I don't really think about any of that. Warner cannot meet the burden to prove clear and convincing evidence that Wood and the alleged statements were false. I'm not sure he has to. Warner himself publicly bragged when he showed groupie to his manager. His manager said, "Please hide the masters. If anyone sees this, you go to jail and your career will be over." In the same discussion, Warner joked that the actress may have been under 18, and Andy Dick claimed that people started bleeding at some point. Andy Dick got to mention this. It's been a hot minute since I heard his name. Moreover, in a publicly filed complaint, one of Warner's victims alleged that Warner made her watch groupie. The actress looked like a young teenager. She repeatedly asked Warner if the girl in the video was dead, but Warner would not answer. So basically, it's the same philosophy as what was it, Blair Witch Project, where they tried to pretend that the people in the Blair Witch movie really were dead and it really happened, and they wouldn't let the actors like come out and say, "Yeah, we're still alive." And like they tried to pretend that they really were dead and it really was found footage, and some people really believed it. So Warner's trying to pretend it's real, like, so it's kind of like Blair Witch Project in that respect. Anyone remember the Blair Witch Project? Okay. They're entitled to attorney's fees and conclusions. All right. So yeah, I'm not so sure about any of that, to be honest. I think the problem is a lot of it just becomes a battle of facts. As to the letter's existence in litigation and in formal hearings, I think Wood is probably right. The filing of the document in the proceedings itself is not attackable for many of the reasons she says. I think that's right. But as to the conspiracy elements and stuff, and like the letter got shared by someone somehow, and if she was engaged in a conspiracy with Gore, which is the allegation, then, might be doing that. Hello. Hello, SD. How are you doing? A. Henninger, I do remember people saying this real? Yeah. So, yeah, exactly. So here's a formal declaration of Evan Rachal Wood, who I keep calling Evelyn for some reason. One of these days I'll get her name right. Cool Spirit, I think, gifted 10 Uncivil Law memberships. Well, thank you very much. Cool Springs. I had to make your name a little bigger so I could read it. Cool Springs. Thank you very much for gifting 10 memberships. That's really, really cool. We really appreciate it. Thank you. Let's see. So let's read a little bit of this declaration. I've been working as a professional actress since I was 5. I met Brian Warner in 2006 at a party at Chateau Marmont when I was 18. My relationship with Warner began as a friendship under auspices of a professional collaboration. Then one day when I was about to leave town, Warner kissed me. I was 18 and Warner was 37. Well, if you're both adults, be happy. I began a romantic relationship that continued on off until 2010. I was photographed by paparazzi. There were many articles written about it. At the beginning of the relationship, Warner would tell me I inspired him to make music and art again, that I was a soulmate and he loved me. However, the relationship became increasingly abusive. Thank you. Thank you, Mama Six. Thank you for your prayers for Stephanie. I'd appreciate it. Appreciate all you giving some prayers and thoughts for Stephanie. She has been a significant person, a significant friend in the last 2 years, and I really, really wish her well. I'm worried about her. I hope that she's fine. I hope she's going to be okay. During our relationship, Warner purulently assaulted me, massively physically abused me, beat me up, starved me, deprived me of sleep, and shocked sensitive parts of my body, isolated me from my friends and family, hacked into and monitored my email and social media, and threatened my lives and friends and family. So she's telling a pretty horrific tale, to be sure. And she is an awesome person, yes. She's an awesome person. 2010, I found courage to end my relationship with Warner. After I left to go film the Ides of March, I changed my telephone number and left Warner for good. I did not see him for years. I ran to Warner at an event in Los Angeles. Before I left the event, Warner would not presumably leave me alone. At one point, leaned over and said, "I'm going to F you, kid. F your kid." Over the years we were together, Warner made many threats against me, which made me fear for myself. Although I escaped from a relationship, coming to terms with the effect of abuse, feeling safe enough to talk about it, I did not begin speaking about the violence I experienced until 2016. Once I began speaking about the abuse, I connected with other activities, including some other people. I testified before some of this stuff. I testified before Congress. I approached Gloria Aldred, who, of course, makes an appearance in this for some reason. My experience led to me advocating to extend the statute of limitations for domestic abuse. I testified before the Senate. I told Amy Berg about the Phoenix Act and work I was doing to extend the statute of limitations, do a 2-part documentary. I met with some other victims of Warner, filmed a documentary. I named Warner as abusive. I've never pressured anyone to make false accusations against Warner to be part of the Phoenix Rising documentary. The statements I made about the abuse inflicted by Warner are true. I have no reason to doubt the accusations made against Warner by other survivors. I'm familiar with Warner's 2002 statements about the groupie movie on Dinner for Five and the civil complaint filed against him by other victims. I'm also aware that accusations of physical and abuse have been made against Warner. I posted copies of letters from Massachusetts Representative Neely Higgins and Florida Representative Anna Eskimi requesting FBI investigation Warner based on the allegations. Here's a true and correct copy. So she seems to at least say she believes it. I mean, she's making some pretty strong accusations. They're making some pretty strong accusations. I learned Warner had been making threats against people who were accusing him of crimes. In November 2020, I made the decision to reside exclusively in my home in Tennessee. Tennessee's a cool state. Thereafter, a dispute arose between myself and my ex regarding shared custody. My lawyers and I filed ex parte. In my declaration, I attached a copy of the FBI letter. I did not distribute the FBI letter outside the scope of my custody dispute, did not provide a copy to Warner, did not leak it to the press. I did not fabricate or forge the letter. When I received a copy of the FBI letter and submitted to the court, I believed it to be authentic. Okay, I mean, all right. My intention in filing my declaration, which is attached to the FBI letter, was not to cause Warner distress, rather to explain why I left. Okay. And here's a copy of the FBI letter, which is, just the most informal thing ever. Some Instagram posts I've made regarding some things, Instagram, so forth and so on, Exhibit 3. So, various stuff. So that's what we've got for today. And we'll sign off for now.